Welcome to session 2 already, with its focus on key cases highlighting the use of national legislation to counter hate speech. It's an important session, not only because it engages with the problematic nature of hate speech, but because it also engages with the problematic nature of preventive or responsive legislation when it is designed and or applied in ways that are not consistent with human rights standards. My name is Tarla McGonigal. I'm based at the Institute for Information Law of the University of Amsterdam. The main focuses of my research are freedom of expression, minority rights, hate speech, pluralism in the media and in society. By the end of this session, my panelists are going to hate me because I intend to enforce a very strict timekeeping regime. So let me take this very brief moment when we're still on friendly terms to speak on behalf of all of us. And I would like to just thank the organizers for the kind invitation to be here. And I think we're all very much looking forward to lively sessions over the coming 2 days. I've already mentioned the timekeeping. My problem here is that I've got a hopeless lack of time and a wonderful abundance of expertise. I've got 5 panelists, a paper presentation, and I've got all the expertise around the table. I want to maximize what I get out of all of those, all of the input available to us. So without further ado, I'd like to introduce the panelists one by one, and they've got 7 minutes each. It's a magical number. Go for it. I prefer not to see this as a restriction, but as a challenge. You should sharpen your arguments, crystallize them, essentialize them. And it's my pleasure to give the floor to Dr. Barbara Bukowska from Article 19, who's going to set a wonderful example in timekeeping. The floor is yours.
Okay. Hello everyone. So again, my name is Barbara Bukowska, and I represent an organization called Article 19, which is an international organization based in London and which takes its names from Article 19 of Universal Declaration, which guarantees free speech. And by name, our organization promotes and protects freedom of expression in different parts of the world. And it's a pleasure to be here because Article 19 has been addressing the issues which are a topic of this conference since its creation in 1988 through various approaches, through critiquing legislation which are adopted to target hate speech, through supporting cases, and through policy and advocacy work. Recently, actually not that recently anymore, in 2009, we developed a set of principles called Camden Principles on Freedom of Expression and Equality, which deal with this very topic. But because I only have 7 minutes, and you know the work which Article 19 has done and our measures how we tackle the issue could take forever, I will limit my presentation on making few observations, and then I will make one set of recommendations. In terms of observations, I would like to start with commenting on a framework or a conceptual framework in which these issues are discussed. And I would like to point out that we believe that the points of departures usually start wrongly, because the emphasis are usually done on a rather balancing act of freedom of expression and right to equality or non-discrimination, rather than looking on how these two rights, freedom of expression and freedom from non-discrimination and equality, should be seen as mutually enforcing and complementary. I think the freedom of expression is seen often by, not by just governments, but also by civil society groups, minorities, as threat to equality. And it's not seen as a foundation right, which should be seen as one of the key rights in ensuring equality and strengthening the cells of autonomy and formation of collective identities of minorities. So Article 19 recommends that this, and this is also what we have recommended in Camden Principles, to approach this within the mutual reinforcing nature of two rights and focus on this nature as a point of departure. My second observation is that this approach also results in a misunderstanding of international obligations of what should be prohibited and how when limiting hate speech. As Frank Laroux has already commented in his opening presentation, under the international legal framework, under Article 19 of the International Covenant on Civil and Political Rights and Article 20, and as also recently reaffirmed by the Human Rights Committee in its general comment number 34, only certain discourse should be prohibited. And by prohibited is meaning in the prohibition in criminal law. However, despite the fact that this prohibition on criminal law should be seen as the last recourse, the states put more emphasis and also in their recommendations or in their reporting to performance under this treaty, they usually focus on how they tackle the problem in their criminal law prohibitions. This is also clearly seen in the interpretation by courts, by judicial authorities, and by a regional body, in this case the European Court, which can be characterized as inconsistent, patchy, and confusing. Unfortunately, there is no uniform test developed under the European Convention and under the jurisprudence of European Court on how the hate speech cases, on these cases in which hate speech is alleged as the reason for limiting freedom of expression, how they should be assessed and tackled. And then they consequently in domestic legislation and domestic interpretation, this results in confusion. So we see that the cases such as the Twitter who comments on the football collapsing on the field, or the fashion designer who makes a comments in the bar on some anti-Semitic comments, or gallery which puts up an exhibition that it's found offensive by certain religious minorities are criminally prosecuted and penalized and are given or are prosecuted under criminal law or given the sentences. So this is a wrong approach, and this is not what is intended by those prohibitions in the Article 19 and Article 20. So what we see is, as I said, a very confusing and inconsistent and patchwork approach in both domestic legislation and the regional, at the regional level. So in order to put some consistency or to unify and recommend a consistent approach and thorough approach, and this is where I'm already moving to my set of recommendation, Article 19 has devised what we call a sort of free-tier approach to regulating hate speech. This free-tier approach is based on what I said before, the fact that under Article 20 and Article 20 of the International Covenant on Civil and Political Rights, only certain speech which amounts to advocacy to hatred and which constitutes incitement to discrimination, hostility and violence can be prohibited. And how this free-tier approach should be approached and how should be implemented in domestic and regional framework is as follows. The first is the obligation or focus on positive measures to promote equality, tolerance, and plurality. Article 19 believes that these requirements and these efforts should center on the measures that challenge the forms of prejudices and tolerance that the hate speech is symptomatic of. And in all instances, the focus should be towards the fostering plurality, further dialogue and engagement, rather than suppressing contagious viewpoints through censorship. These positive measures should start with comprehensive freedom of expression and anti-discrimination legislation and their implementation. The the framework in Europe is set, can be followed from what is said by the set of directives at the European Union, but also by a number of recommendations and policies which have been adopted at the Council of Europe. There are many further examples of what should be done by this positive policy approach, but I want to highlight, and some of them were already mentioned in the opening presentation, but I want to highlight another one which hasn't been yet mentioned, and that is the approach by politicians and public figures who should be held to higher standard by their domestic laws and also the ethical standards developed for various professions. There should be also the broader societal campaigns and educational measures done for the society as a whole, but also for the media. Secondly, only when strictly necessary and proportionate, these positive measures should be complemented by coercive legal measures and sanctions to suppress the speech that is deemed harmful. As for the criminal law, Article 19 has devised a test under which these cases should be evaluated. And Frank Laroux has already highlighted some aspects of the case, and unfortunately I don't have time to discuss this in detail, but the key aspects of this test should be the clear definition of key terms enumerated in Article 20 of the ICCPR, of what is meant by hatred, what is meant by advocacy, what is meant by violence and discrimination. Then should be an extensive approach to grounds on which discrimination, hostility and violence should be prohibited. Those should not be limited to grounds of ethnicity, race and religion, but should also encompass all other grounds which are prohibited by international law, namely sexual orientation and gender identity and disability and other status such as immigration or in other parts of the world, tribe, caste, and so on. When evaluating the cases, the courts should always look on whether the level of severity is it already? Okay, I will rush through it. The level of severity is reached, and this should be assessed by criteria such as whether there has been an intent to really incite to violence, discrimination, or hostility. What was the context of the speech in terms of the speaker and in terms of the audience, but also in terms of the minority or a group against which this hate speech is targeted. There should be also assessment of the possibility of imminence of such harm occurring, and also the causality links between the speech and the harm happening in fact. There should also be, okay, so I'm having now 1 minute, but these criminal sanctions, which should be also proportionate to the actually what has been advocating, should also be complemented by civil law and administrative sanctions, which would provide recourses to the victim to seek damages and other forms of redress. The third tier of this approach also puts emphasis on the position of victims and position of the groups against whom the hate speech is targeted, and here we call for more possibilities for involvement of the groups in those legal procedures that are devised for their protection. At the moment, in the criminal law, which I have emphasized has been the focus of the countries, there is only a very little possibility of victims to participate. And in terms of civil remedies, there are also various barriers, such as high legal fees or lack of legal assistance, which don't really provide victims the protection they deserve. So the states should also jointly devise the mechanisms that would include the possibility of victims to participate in these proceedings. So within these three approaches, we believe that the international obligation to both protect freedom of expression and promote equality would be thoroughly implemented. And I'm happy to discuss these components in greater detail in further discussions. Thank you.
Okay, thank you very much for that. I'm now immediately going to backtrack from my initial enthusiasm and presenting it as a challenge. It really is a restriction, but thank you for trying to keep within the time. One thing that I should say is that there will be an opportunity for the panelists to come back to respond to questions at the end. So please, when you're listening to the panelists, focus on some of their key points and ask the questions, and that'll keep the discussion moving. It also gives panelists then a fallback for later. I'm very glad that you mentioned the comprehensive approach that's required and that it should include positive measures, because what I should have mentioned at the outset is that central to this session is an invitation, a collective invitation to reflect beyond the problematic nature of hate speech and legislative responses to hate speech, to think in broader terms about possible solutions or how those regulatory responses could be better calibrated in order to deal effectively with hate speech in a way that is consistent with human rights. So please take that extra step in your thought processes as you're listening to the speakers. Thank you again for that first contribution. The second panelist, would you like to come up here to use the PowerPoint, or do you want me to? Okay, I can perhaps click on the slides. It's my pleasure to give the floor to Dr. Daniel Milo, who's going to present some case studies from Slovakia. He is Director of the Department of Equal Treatment and Gender Equality at the DG of Human Rights and Equal Treatment at the Office of the Government of the Slovak Republic. So again, if it's not inconvenient for you, it might be easier to come here. Gives you more control over the pace of the discussion. While we're getting this set up, I might take one quick question relating to the first presentation, and we'll save the answer then for later. Anybody want to get in on the comprehensive approach to combating hate speech? Positive measures? Relationship with equality? No? Okay. Plenty of time.
Good morning, ladies and gentlemen, distinguished guests. Even though the title of my presentation is Cases from Slovakia Illustrating the Use of National Legislation, I would rather focus on challenges of using national legislation. Maybe to briefly introduce myself, even though I represent here state authorities of the Slovak Republic, I've been dealing with the issue of hate speech and hate crimes for a number of years as an NGO activist and then at international level within the OSCE. So the issue of finding effective remedies against hate speech while protecting freedom of expression is not a new one. It's not a new challenge. However, the unprecedented expansion of the internet and its various platforms, mostly the so-called Web 2.0, and its user-generated content in recent years has made the effective application of national legislation countering hate speech and incitement to hatred and violence more difficult than ever. Internet, due to its character, this public piazza, as it was stressed in several previous presentations, not only stimulates open debate and exchange of opinions, but its perceived anonymity also encourages to express views and opinions which their authors wouldn't dare to present in public standing on a soapbox. However, since such views and opinions are freely expressed and shared, even though they sometimes constitute an offense under national legislation, they are perceived as legitimate and in turn affect views and attitudes also in the offline world. This relationship between online and offline hate has been documented in many cases, for example in the case of Breivik, and this issue was analyzed also at meetings of international organizations such as the OSCE. which organized several meetings on the subject. Since my time is limited, I will provide you with a very brief overview of legal framework which is in place in Slovakia. Basically, Slovakia is a party to all major international conventions, including ICCPR, CERD, CEDAW, CRC, and all the others. And therefore, Article 26 of the Constitution of Slovak Republic guarantees freedom of expression. And at the same time, its Section 4 sets clear limitations. And these limitations are in line with international principles which were also presented in the morning. Slovak Republic adopted an approach of regulating hate speech by using criminal law. And therefore, the Criminal Code of Slovak Republic contains specific articles prohibiting incitement of hate, defamation of race, nationality or religion, as well as public denial of Holocaust and support to so-called extremist movements. I wouldn't go into much detail describing these articles, but rather I would like to give you an overview of how difficult it is actually, even in countries which have such limitations in their system of legislation, to actually implement it. These limitations are closely linked, of course, to the nature of internet, which disregards national borders. Content is created in one country, uploaded or stored in a second one, and accessed or shared in a third one. So it's very often the case that 2 or 3 different countries with different jurisdictions and legislation, of course, are involved in any single case of hate or violence inciting content, which is, of course, aimed at a particular audience using a particular language, and therefore it is aimed for one specific country, in this case, Slovakia. Different approaches towards countering and legislating hate speech are well known, and the so-called Atlantic divide is probably the best example of it. The issue of different countries and jurisdictions is only one challenge related to application of national legislation in cases of hate inciting content. Even in cases when content is created and stored in one country, the vast volume of information created and shared every single day and posted on the internet makes it extremely difficult, or if not impossible, to use national legislation effectively and deal with such cases. Since there are no official data mapping the prevalence of hate inciting content in the Slovak language on the internet, I will illustrate the situation by using data from a research carried out by an NGO, Slovak NGO called People Against Racism. In 2010, this NGO carried out a monitoring of Facebook groups which advocate violence and instigate hate towards Roma. And these are the numbers from this monitoring. This monitoring basically proved that yes, the hate speech is prevalent on social networking platforms. They identified 360 groups and 1,760 cases of violation of criminal code. These are the most serious cases which called for violence and were very open in their nature. What is maybe even more worrying that, as you can see, 460,000 sympathizers were in those groups. I'd like to give you 2 examples of this content. You can see the translations because the original submissions were in Slovak language, and one such comment was, "These damned parasites, if the state didn't give them money for all the social benefits, we would be much better off." The so-called misuse of social benefits is a very widespread phenomena. But what is maybe even more worrying, there were many calls for violence against Roma, such as this one. We just have to shoot those black apes. Of course, there is a connection between online and offline hate. This is just another example of so-called racist jokes or statements which are clearly seen as defamatory. This picture with the title "A Swing for Roma Kids" with the gallows in the background was widely circulated on Slovak internet. Now I would like to illustrate this connection between online and offline world on this particular case. In 2010, in Bratislava, there was a lone shooter who went on rampage shooting. He killed 7 people. But the way media portrayed this case was from the day one very biased and helped to create again a picture of Roma as people who do not respect the law, and therefore even act of violence against them is legitimate. 6 victims in one family, one of them was 12-year-old child, but only one of them was Roma. Despite these facts, the media from day one portrayed this as an act of revenge against Roma, and there was a wave of anti-Roma hate speech all over Slovak internet. And this is again an example of the connection between the two worlds. The lady on the picture, she's a former prime minister of Slovak Republic, and someone created this picture and then shared it on Facebook, saying, yes, this is a non-standard solution of the so-called Roma issue, but it proved to be a very effective one. And the picture she's holding, of course this picture was photoshopped, is the picture of the shooter. So you can see how even cases such as, a murder of 6 people is being turned against the victims and being blamed on Roma. Since I have only 1 minute left, I would skip the other examples, which are numerous, but I'd like to point out the legislation could be an effective tool only if its users, the law enforcement officers, prosecutors, judges are well educated and trained to use it. Secondly, given the vast number of such cases of online hate, it should be used only as a strategic tool, primarily in cases where it is likely that it would lead to a successful conviction. Application of criminal law in all cases involving hate speech on the internet would overburden the criminal justice system, and the outcomes are dubious. Thirdly, due to the length of legal proceedings, use of legislation, in this case criminal legislation, is not an effective remedy for removal of the content itself, since the criminal proceedings are author-focused, and even if the author is convicted due to differences in jurisdiction and legislation, this doesn't have to lead to removal of the content itself. I think this will be discussed in the later sessions, but based on this experience from application of criminal law prohibiting hate speech and incitement to hate in Slovakia, I would say that in relation to content, implementation of self-regulatory measures such as well-defined terms of service or flagging of comments for admin review or complaints mechanism proved to be much more effective than the use of legislation on its own.
Thank you. Thank you very much for that, giving us, amongst other things, reminders, not that they're needed, of just how confronting the real cases can be. Thank you also for bringing the discussion now further in terms of identifying some of the specific problems that apply when hate speech is propagated in an online environment, things like the difficulties in determining jurisdiction and the monitoring challenges that are posed by the abundance of information and hate speech that is available online. This brings us nicely to the third panel presentation. And the focus here will be on how hate speech in digital media affects victims and perpetrators. So also nice continuity with the first presentation with the emphasis on victims, amongst others. The case study has been prepared by Professor Stefan Sotio and Dr. Joachim Frielink from the Catholic University of Leuven. Dr. Frielink will give the presentation. It's also a nice opportunity when we focus on digital media to recall our finely tuned tweeting skills. We're used to dealing in 300 characters. You've got a little bit more. The floor is yours.
Okay, thank you very much. I'd like to firstly thank the organizers for organizing this event. It's already been very interesting and of course for inviting us as well. So I'm both a lawyer and a legal anthropologist, so I combine those two perspectives, and together with Professor Stefan Sotio, I've done legal and anthropological research regarding hate speech. And one of those projects was on the intended and unintended effects of the Belgian hate speech legislation, especially regarding racist hate speech. And to this end, we interviewed about 30 victims and about 30 perpetrators, and especially the latter, interviewing the perpetrators, hadn't really been done before in the literature. So to really briefly summarize the whole of the project is that the research indicates, much like some of the speakers already suggested, that the impact of at least criminal law in fighting racist hate speech is mostly negative for both the plaintiffs and the perpetrators, so for the people that are directly involved. It doesn't say anything, of course, about the wider societal effects. We can discuss those at length more later on. And this seems to be, and that's important for this conference especially, this seems to be the case especially for cases in the digital media, mediated cases more generally. Now, in discussing some of the findings in more detail, I'll first give some very brief background information on the legislation that we have in Belgium regarding racist hate speech, and then secondly, I'll only discuss, in light of the magical 7 minutes that I have, I'll only discuss the perpetrators. So the victims will not be discussed, but I'll feel free to ask us about it later on, because if not, paradoxically, the victims will be the victims, which is, of course, not the idea. Okay, so a very brief sketch of the legislation. The legislation we have in Belgium regarding racist hate speech is only criminal in nature, so it's criminal law. And the first one dates from 1981. It's called the Anti-Racism Act. It basically contains a prohibition on the incitement to hatred, incitement to discrimination, and the incitement to violence on the basis of a wide variety of race-related grounds, so race, color, etc. The other provision in that act is a prohibition on the dissemination of ideas that are based on racial superiority and racial hatred. A second piece of legislation, which is more sidely related, is a prohibition on the denial of genocide, and more specifically only on the denial of the Nazi genocide. So the denial, the minimization, and the attempt to justify the Nazi genocide is prohibited by criminal law as well. Now, there's quite a wide range of applications of this legislation, which ranges from really hardcore facts like that were discussed by my previous presenter concerning like really neo-Nazi kind of expressions, ranging all the way to more innocent jokes that are emailed through internet, etc., etc. So quite a wide disparity, which is important to keep in mind. So to come to the practical effects, and specifically regarding the defendant, the legislation's aims are, in the first place, to have a dissuasive effect, of course, on the perpetrators to not utter such expressions, and on the other hand as well to affect a change of mind, a change of mentality in order for them not to re-engage in similar expressions in the future. Now, as for the actual effects on these defendants, there's a relative distinction between several categories, and I can't discuss all of them, so I'll limit myself to the two most simple ones, basically. That's the first category is the category of the most radical perpetrators. I term those the offenders by conviction. The other category I'll discuss is those are the most moderate perpetrators, basically, and I refer to those as the incidentalists. And the effects of the legislation are quite different between these two categories, but the common denominator is that the aims of the legislation are rarely achieved, and it leads to, that's more important even, it leads to all kinds of negative side effects, so all kinds of counterproductive side effects. Now, to start with these most radical of perpetrators, these offenders by conviction, these are really the radical racists. These are self-proclaimed Nazis, so it's not something that we labeled them. They call themselves Nazis. They're very often also religious fundamentalists, and these people tend to violate the legislation in very consciously and in a very far-reaching manner. So there's not really any discussion about whether or not the legislation has been infracted. Now, as for the effects of the legislation, as soon as the law steps in, the dissuasive effects or the change of mentality that the legislator hoped for in making the legislation do not occur with this category of perpetrators. Quite the contrary, rather. What you see is that these people actually welcome, paradoxically, they welcome their prosecution, and they often even actively invite them. So one of the perpetrators, for instance, always sent all of his publications, this was a Holocaust denial, he always sent all of his publications to the equality body that's responsible for enforcing the legislation with the requests of him being prosecuted. And why is this? This is the fact because these people are so radical, they have very limited other means of reaching mass audiences than when the media actually pays attention to them when they're being prosecuted. So for them, the fact that they're being prosecuted is a means to finally gain entry to the mainstream media instead of just uttering their expressions on the internet, where very few people actually take the trouble to surf to their marginal websites. So one of the people, for instance, who was prosecuted, he always went to court wearing a T-shirt with the web address on his T-shirt printed in order for people who looked at photos or looked at the images that were portrayed on television for them to come to his website in order to try to convince people. Furthermore, the prosecution of this category of perpetrators, you can see, have unintended psychological effects as well. For instance, it actually reinforces their racist and all kinds of conspirative ideas. They see their prosecution as proof that the system is out to get them. Because they see the world for what it really is. They wouldn't be prosecuted if they didn't, etc., etc. It also infuses them with a sense of their own importance. They often make comparisons with religious figures. There was one of the perpetrators who, when I asked him how he felt about being prosecuted, he said, well, it's only natural because Jesus was prosecuted as well. These types of comparisons, these delusions of grandeur, if you will, quite often pop up. Moreover, and that's even more important, I think, in the context of hate speech, it also has unintended social effects. So the prosecution actually leads to these radical people being perceived within their in-group with more respect, because it's seen as some sort of quality label. They're part of the group as soon as they're prosecuted, and it instills the in-group with a sense of the importance of the person that is being prosecuted. And related to this is also that the prosecution and the media attention that it receives actually facilitates, paradoxically, contact between like-minded people with whom they previously weren't in contact, because, as I said, the media attention draws attention to the situation, and then people will start to contact each other who formerly hadn't been in contact. So the legislation actually has a group creating a group reinforcing effect in that regard, which is something you may not want to do with neo-Nazis. At the other end of the spectrum, so these were the most radical perpetrators, at the other end of the spectrum you have these so-called incidentalists. And these are a completely different class of people. It concerns people whose expressions for which they are prosecuted are non-recurrent. It's just a one-off incident, hence the name incidentalists, and who are not part of any organized groups. So the expressions for which they are prosecuted, they tend to be much more contextual, and they're not part, in any case, of any large systematic underlying body of ideas. So for instance, for some people it concerned racist abuse during a discussion after a traffic accident with someone from foreign origins, or it concerns people who sent jokes through the internet with a racist connotation, which are subsequently prosecuted. Now these defendants are usually taken by surprise by their prosecution. What you can see regarding the legislator's intent is that recidivism, so the reoccurrence of similar effects, did not occur within this group. So the dissuasive effects that the legislator hopes for do seem to occur with this category of defendants. But what you see as well is that in many cases the dissuasive effects actually start to become so-called chilling effects, far-reaching chilling effects as well. So they resulted in the suppression of legitimate speech, and even in the conduct of many of the people who were prosecuted, out of fear for renewed stigmatization, out of fear for renewed prosecution and penalization. So, for instance, some respondents imposed very far-reaching limits on their speech, on their communication. There was a person, for instance, who had been, like I said, convicted for sending a racist joke by email, and he stopped sending non-business related email altogether, just to be sure that he wouldn't be prosecuted again. And he, as well, also no longer went to certain public places, which he didn't know because he never knew, in his own words, whether it was a safe place to speak, etc., etc. So they're really quite intimidated by these types of events. And what's striking as well is that these effects are not limited to people that are convicted. So they also occur when the prosecution ends up in an acquittal, or if the cases don't even go to court in the first place. So the reason for this is basically that the consequences of the prosecution that occur for these categories of perpetrators are very significant socially, because these incidentalists, unlike, of course, these offenders by convictions, they're not included, they're not supported by some sort of ideological community that supports them or that even is enthusiastic about them being prosecuted. Quite the contrary, of course, if you're prosecuted for racist expressions, that has a very significant, if you're a normal person, it has a very significant societal stigmatizing effect. Some of the respondents were, for instance, fired even before their court cases were finished, so even before the issue was settled on whether they were guilty or not. In many cases, relational problems ensue, and yeah, I'll finish up. And at the same time, that's a final remark that may be interesting. At the same time, what happens is that these people are sometimes approached by members from more radical groups, as it becomes known, again through the media mostly, that they're being prosecuted. So what you see is that at the same time that other social networks kind of crumble on account of them being prosecuted, they're actively try to be enlisted by more radical groups, which actually has a danger of, well, further radicalization rather than the effects that the legislator hoped for. I'll leave it at that for now, and I'll give the chairman the floor back.
Thank you very much for that, and sorry to cut you off when you're prizing the discussion open in such a fruitful way, exploring new dimensions to the problem. But I'm very confident that that will come back in the one and a half questions that the time will allow us. Thank you. I'm going to move then to the next panelist, and that's and the focus here will be on legislative responses to hate speech, according to the program. And that the panelist then is Professor Yasemin İnceoğlu.
Yeah, İnceoğlu.
Okay, yeah. The floor is yours. Thank you.
Thank you. I don't like reading, but I think the best thing to do is that in order to catch up the time, I'm going to be fast. Mainstream media in Turkey, time to time, deny humane values to otherized groups and justify and legitimize humiliation and violence inflicted on these groups. While media reproduce nationalism and racism as tools of the hegemonic ideology, they also produce social change and hatred and cause these feelings to be forwarded to the others. The European Commission 2011 Progress Report on Turkey emphasizes that anti-Semitism and hate speech in the media targeting missionaries or Christians in general remain an important issue. The Association for Social Change is a leading organization focusing on the hate issue in Turkish media. I'm one of the members of the advisory board of the association. Our 2009 report, which was supported by the Open Society Foundation, entitled Hate Speech and Hate Crimes in National Media, 10 Years, 10 Cases, covers the years between 1998 and 2008 and focuses on a large selection of newspapers that represents most political and ideological sides in Turkey. Researchers investigated hate speech instances in 10 categories, including ethnic background, nationality, gender, sexual orientation. We don't say it's sexual preferences, we say sexual orientation, and religious affiliation. Of the 30,000 articles and commentaries investigated, the researchers analyzed 200 pieces in detail and provided 10 textbook cases of hate speech for each category. According to this study, 47% of all hate speech instances are related to ethnic identity. It's followed by religion, 20%, national identity, 11%, and political affiliation, 11%. This study also revealed that there is more hate speech against certain groups in certain dates. For instance, before or on April 24, Genocide Remembrance Day in Armenia of every year, there was a recognizable increase in the negative and discriminatory discourse against the Armenians. Similarly, before or on March 21st, Newroz discourse against the Kurds and the Kurdish identity was more offensive. Another important thing that must be mentioned here is that hate speech about sexual orientation or sexual identity is common in almost all newspapers, regardless of their political and ideological affiliation. The topic was legislation about hate speech, but unfortunately in Turkey we don't have a hate speech legislation. But fortunately we are working now on hate crimes legislation. You'll be asking why, because in Turkey we really have a big rise since 2007 with hate crimes, and hate speech generally ends with hate crimes in Turkey. And a very good example is the murder of the Turkish Armenian chief editor of the Armenian Agos newspaper, Hrant Dink. I'm sure most of you have heard about him, in front of his office in 2007. Dink was killed because of his Armenian identity. According to court documents, the murderer, Ogün Samas, didn't even know Dink's proper name. He just knew that he was an Armenian. Dink was identified as a target not only by the nationalist and discriminatory media, but also by the media publishing in line with Islamism. Hrant Dink had been made a target by the media within 10 days after Agos News. It's a big story, but for the ones who are interested, I have articles on it, because I also made the media coverage between 2004 till 2007, the date where he was murdered. All the media coverage, how he targeted him, how the headlines were, it was awful. And in its verdict in 2010, when the European Court of Human Rights convicted Turkey in the Hrant Dink murder, a major mission was given to the Justice and Development Party, the government, on the subject of hate crimes. The Turkish Penal Code does have legislation against spreading hate speech, Article 216. Ironically enough, this article is being used to silence dissident voices, especially Kurdish politicians and journalists are being convicted of it. For example, when they demand more rights for Kurds, or if they file reports about PKK fighters, it's a typical example of that legislation. And the article is a sister of infamous Article 301, that Hrant Dink was also sued, that makes insulting Turkishness a punishable offense. I told that we have a lot of hate crimes that occur in Turkey, but they don't always mostly they don't take place in the media. We have in 2006 Friar Santoro, the priest Santoro's murder in Trabzon. I told Hrant Dink's murder, massacre of the Malatya Zirve publishing company just because they were publishing the Bibles. The attempted lynching of Roma community in Selendi, Manisa, near Izmir, or prehistoric Smyrna, 2010. The violent acts against Kurdish people in different provinces and districts, and the frequent LGBT murders covered by the media are all examples of hate crimes. Why do we need a law of hate crime? We can all see why. Civil society groups and individuals that demand hate crimes legislation in Turkey have created a platform. I'm working for the platform. Our lawyers of the platform are preparing a legislative draft on the prevention and punishment of crimes of hate. The purpose of this legislation is to punish crimes of hate in an effective manner. According to the draft, the definition of the hate crime is any systematic process used against person or any group belonging to a specific race, ethnic origin, color, religion, language, gender, sexual orientation, sexual identity, status of health, physical or mental disability, age and social status, or any other characteristics targeted for the purpose of with the intention to commit crime is defined as having bias or prejudicial motive, and the coverage of this law is covered and limited with the points mentioned in the Article 5237 of our criminal code. I think 7 minutes done. I will answer the questions if anybody is interested. Thank you very much.
Right, you're the first panelist whose hand I will shake during the coffee break. That was wonderfully on time. I'm going to move straight away then, thank you. I'm going to move straight away then to the fifth panelist, Dr. Peter Molnar, who is a Senior Research Fellow at the Center for Media and Communication Studies at the Central University of Budapest. His focus is going to be on the particularities of artistic expression and symbolic expression as they will interface with hate speech. So, 7 minutes, go for it.
Thank you. So, thanks for the organizers. Imagine that we are in the parliament of a European state and we are under pressure to do something because so-called hate speech is growing and there is some violence that might be related. And of course, as members of parliament, we are under lots of other pressures. Among other things, we need to do budget cuts. So there are several proposals in front of us, and as we are in Europe, and content-based restriction of speech, of so-called hate speech, is largely accepted as the mainstream European approach. There is such a proposal in front of us, and it is not precisely defined what is so-called hate speech, but the proposal suggests let's prohibit it. So I suggest that would be the easy response, that would be the easier response, that would be a lot easier than create a framework for diversity and pluralism, which would include facilitation of counter-speech by disadvantaged minorities like Roma people, because that would cost money, that would mean that we should go against the prejudiced majority. So I think that that's a trap, and all European states often fall into that trap, and this is not just a symbolic problem, this causes damage, and this hinders our ability to respond to so-called hate speech more effectively. So I suggest that going for the traditional, I put it this way, traditional mainstream content-based restriction on so-called hate speech in Europe, which is the mainstream response in Europe, is an ersatz displacement that is causing damage. And it needs to be reframed, reconceptualized, and we need to rethink it. And I want to bring up Hungary as an example. Of course, unfortunately, I cannot mention Hungary convincingly as a best practice place these days with our huge right-wing supermajority government and an extreme right-wing party which is also in the parliament. But still, I want to mention the framework to respond to hate speech legally in Hungary as an example which can help, I hope, the rethinking of regulations and responses to so-called hate speech. And stepping back for a second, and again, how it's connected to extra legal responses is that, again, we are members of parliament under pressure. If we restrain ourselves from content-based restrictions, I think that pushes us to look for other extra-legal responses, like facilitating counter-speech of disadvantaged minorities as part of the broader diversity and pluralism framework. So, just now coming narrowly to regulation of such speech. There are two schools. One is the content-based regulation. It is based on the argument that such speech is harmful. It makes us feel bad. It makes survivors of a genocide bad. It makes attacked religious groups feel bad. And also, the content-based restriction approach argues with danger that speech causes, but it doesn't really go into the issue how immediate is that danger. So I suggest, and that I raise it as a question as well, I suggest that we need to focus on danger. I suggest let's accept in Europe that offensive speeches should be fine, not in the sense that it cannot be ugly, but all sorts of speech all the time offends many of us, and we need to live with that if we take freedom of speech seriously. So I suggest that sort of emotional harm, as bad as it can get, it's not a justification for criminalizing speech. So then I think, or if someone suggests that content-based restriction is fine, then I really want a solid definition of how context matters. So if so-called hate speech is expressed in a context when it's very harmful emotionally, is that enough to restrict it? What if a racist majority would say that it's very harmful to me that a desperate Roma rights activist says that my country is a fucking racist country and I hate it? What if the prejudiced majority says it's really harmful to me, I don't want to be called racist? And then the Roma rights activist is prosecuted. So I suggest that the danger test is more helpful, and that focuses on danger. And then I suggest that we need to, and that's what we have in Hungary. So in Hungary, the courts, the Constitutional Court and the General Courts created a Hungarian version of the American danger test. It is about imminent danger of violence. So that is when criminal law can suppress speech. But importantly, intent is not required. So that is another thing that I want to put on table. Usually it's accepted, let's have intent as part of the legal regime against so-called hate speech, so that will be our safeguard for protecting freedom of expression. I think that's not the case. In a situation when speech can cause imminent danger of violence, I think a should-have-known standard is fine, or at least courts should be able to infer intent. I know that we will need time to discuss it in breaks and maybe with questions, but I want to put it on table. Also, I suggest that when we consider whether speech created imminent danger of violence, just one more minute, then we need to think about the broader environment as well. So if there is an extreme right-wing racist party in parliament, so if there would be some racist people among us, if we are a national parliament, that matters. Then a judge in our country should say that speech in such a broader environment can more easily create imminent danger of violence, so we can justify restriction, criminal or restriction of that speech under the danger test as well. And also referring to the online thing, if internet is used in an instrumental way, somewhat similarly as that infamous radio station was used in Rwanda to incite and instruct violence of course, that can also be suppressed under the danger test. So what I'm suggesting is not that we should not use criminal law at all. I just suggest that we should make it a lot more clear that on what grounds in Europe we want to suppress so-called hate speech, and I suggest that a carefully elaborated understanding of an imminent danger test is a lot more helpful than a somewhat obscure understanding of content-based restrictions based both on harm and danger. And of course, we can add, and just really 2 more sentences, we can add other restrictions, like in Hungary, in the media law, we have media-specific restrictions on so-called hate speech on radio and TV, considering the special impact of radio and television. I think that's justified as an exception. And also, we have 2 other exceptions by criminal law, that even criminal law in Hungary prohibits the use of certain totalitarian symbols, and since recently, Holocaust denial and denial of crimes committed by the communist regime. I think those exceptions are very questionable, but the main rule is that criminal law is based on the imminent danger test. And
Peter, I've got a wonderful way of cutting you off. I'm going to refer everybody to your forthcoming book that's available next week. The flyers are outside.
Okay, thank you. I made my point. Thank you.
I'm terribly sorry to cut you off, but we've got one more offering before we conclude. We were a few minutes late starting, and I think it's only fair to have the required time for the paper presentation. So I'd like to introduce Władysław Belawusau, who is Associate Professor at the Vrije Universiteit van Amsterdam. You've got an elevator pitch, but it's quite a high elevator. It's 5 minutes. The floor is yours.
Thank you very much. You were extremely skillful with pronouncing my conventionally unpronounceable name. Thank you very much. Well, it's my pleasure to be here. I can but say still a few words of gratitude. Actually, I'm the alumni of this institute, so for me it's déjà vu of happy return. And I happily defended my doctoral thesis at the European University Institute to share some responsibility. As Germans would say, I had 2 Doktorvaters, so one of them is Professor Wojciech Sadurski, and the second one is here, Giovanni Sartor, so it's my pleasure to see him. And of course, I welcome the opportunity of the creation of the center. While doing my PhD for 4 years, and that was a very broad theme of comparison of European approach to freedom of expression and the American approach regarding 3 areas: hate speech, historical revisionism, and pornography, I always felt that my research is somewhat of a Cinderella. Whenever I was trying to push forward some initiative dealing with hate speech, I was getting the response, could you talk about pornography? At that moment, I realized that sex pays better than hatred, which is a good thing. Which means that I was doing my PhD at the right place, but in the wrong moment. Thank you for the creation of that institute and the invitation. Since my academic freedom of speech is constrained vigorously by time limits, and also there is a non-discrimination element because of preventing everybody joining the coffee break, I'll try to gloss over most of the things from my paper, which recently was published online in Amsterdam Law Forum and is upcoming soon as a book chapter in a book authored by many scholars on EU non-discrimination law. Basically, one of the things I liked about the initiative of the Institute, of the Robert Schuman Center, to create the Media Institute is the apparent focus, never pronounced actually so vividly on EU media law. Because as far as the conventional themes of recurrent themes of freedom of expression are concerned, like hate speech, for example, or genocide denial, they are most commonly discussed on the European level within the Council of Europe. So the research, let's say, on hate speech potential or genocide denial potential within the EU law is somewhat of a total Cinderella. So what I was trying to see is whether we could use the current framework of fundamental rights protection and EU non-discrimination law in order to discuss and tackle the issues such as hate speech, so on that pan-European level. So a certain pan-European triangular vision of freedom of expression, essentially going further than just national legislation plus the Council of Europe, but also affecting EU law framework. The never-ending story of fundamental rights in the Union, which is worth of plenty papers, could be summarized with regard to Lisbon very simply, actually. Well, since the 80s, 90s, both the academics and the European Court of Justice pushed forward the mythology of apparently non-apparent fundamental rights as existing since the very creation of the very commercial organization called the European Communities at that time in the 50s, which was later framed into the primary law. So in the treaties, starting from Maastricht Treaty, we do have what is now Article 6 of the Treaty on the Functioning of the European Union, clause on fundamental rights protection. Also, Article 2 says that the Union is apparently based on the values of freedom of expression. The EU law approach in that respect is not entirely original. The only originality, perhaps, is the inclusion of the specific catalogue of fundamental rights, which becomes binding after Lisbon, the so-called EU Charter of Fundamental Rights, which is potentially of interest when discussing issues like hate speech with its apparent mainstream of dignity, which is not present in the European Convention of Human Rights, although widely, or not that widely, discussed in Strasbourg. Then linking the mechanism of fundamental rights protection to the European Convention of Human Rights, as most of you are aware, the EU is to accede that's the obligation from Lisbon now onwards, the system of the Council of Europe. So linking that triangular together, and then of course constitutional, that imagined concept of linking the constitutional traditions of member states. Well, what is original about the EU approach? How can the EU move forward with as far as the non-discrimination is concerned, but then the general realm of fundamental rights, going beyond the possibilities of 47 member states, as different as Azerbaijan and Iceland, within the EU is the creation of the legal base for non-discrimination. So we do have what is formerly Article 13, nowadays Article 19 of the Treaty on the European Union, which gives that harmonizing capacities. In particular, the Council, with the consent of the Parliament, may take appropriate action to combat discrimination based on sex, racial origin, religion, or belief, disability, age, or sexual orientation. So the instrument I'm going to discuss with regard to the, recent or not that recent, case by the European Court of Justice actually affects that piece of harmonized legislation, the so-called EU Council Anti-Racist Directive. The theme of freedom of expression is not entirely new as far as the case law of the ECJ is concerned. And the cases like Schmidberger, Commission versus France, for very distinguished public here who are of course specialists on freedom of expression. I'm going to gloss over them, and many other cases covering advertising, access to information, broadcasting, film industry, public servants and EU procedures, public morality, issues of general harmonization made the court at some point to discuss, very often as obiter dictum, sometimes actually quite specifically the issue of hate speech, which was the issue of the so-called commercial speech. Let's put it in those fake American terms for the sake of that presentation. But it was extremely unlikely, or at least it looked like after the Maastricht Treaty, that hate speech as the theme would ever reach the ECJ, the traditional theme for the Council of Europe and the European Court of Human Rights. One instrument I also have to gloss over, which is of high importance, and of which I'm actually extremely critical, that's the framework decision on combating certain forms of expression of racism and xenophobia. Generally, being a bloody continental European who believes that the incitement of hatred clauses is a good thing, I'm very much skeptical both from the point of view of general human rights and EU law about this instrument. So as a human rights lawyer, I would say that the instrument essentially goes beyond pure hate speech and constructs genocide denial. And moreover, not genocide denial on general, taking just traditional Holocaust denial and bringing it with certain criminal effect onto the EU countries. As an EU lawyer, I would say that it doesn't bring anything new for the purpose of the general harmonization. So the logic of harmonization and discrimination field has always been to go further than the Council of Europe. I don't think that in any way, apart from the criminalization of genocide, which is certainly for me a chilling, is having a chilling effect, and brings us any further. I would need 1 minute to introduce the case, okay?
30 seconds.
But what I'm positive about it, the 2008 case, which is actually a Belgian case, Ferijn, in which the employer was prosecuted for which appears hate speech, although in the context of labor. Well, the remark was, the firm is quite famous in Belgium. They're installing the doors in private houses. So the comment of the employer was, apart from these Moroccans, no one else has responded to our notice in 2 weeks. But we are not looking to Moroccans. Our customers don't want them. They have to install up and over doors in private homes, often villas, and those customers don't want them coming into their homes. The standard. Well, in the subsequent interview, the employer says, by no means I'm racist. That's the Belgian society which is racist. I'm very much welcome to Moroccans. I have plenty of neighbors, girlfriends, whatsoever. But that's the problem of the society. There is no, well, the situation of that case is of fundamental importance for the legal mobilization tactics on hate speech in Europe. There is no a single Moroccan who communicates before the court the prosecution that he or she is not hired by the employer. And still the court finds, moreover finds direct, which is very important with regard to EU non-discrimination law, direct discrimination based exclusively on utterance, essentially hate speech utterance, by the employer. So that's the happy progress. Well, at this moment, I have to desperately say stop to my freedom of expression. Thank you very much.
Right. I've got a creative way of cutting you off. I'll give you 1 sentence to say something provocative, which will invite response, and then you get more time when you have to deal with the response. 1 sentence, go.
Well, if there is one thing which I learned in 4 years, John, discussing freedom of expression as a comparative issue between the United States and Europe, actually this research brought more moral, let's say, like this, uncertainty to myself. And actually, amongst other, I'm very critical of Hungarian approach because that was one of my 3 case studies.
Okay, that's targeted, that's controversial.
And the second controversy, so one thing which I learned, and of which I'm absolutely sure, is that we cannot treat historical revision as genocide denial within the realm of hate speech.
Okay, next time I try that trick, I'm going to insist that it's a sentence without conjunctions and commas. Thank you very much for the presentation. Sorry again to cut you off, but I do want to just get a few people in from the floor before we wrap up. Okay, any questions, responses? And I will give preference to people who haven't spoken already. As I said at the outset, I want to really maximize the expertise that's at the table. Yes. Please.
Thank you. No, very quickly. One of the things that I wanted to raise as a conclusion maybe is that this issue of hate speech cannot be only discussed at the theoretical level, because we have seen on one hand that hate speech can, for example, effectively lead to violent criminal activities, but on the other hand we have seen that prosecution of hate speech is not a way to prevent hate speech in certain occasions. So one of the things that I wanted to raise is that probably hate speech is problematic not only because it can affect individual rights, but also because it can affect something that we, basically the lawyers, we are not used to deal with, which is something called social cohesion. And for example, if we have to deal with, if we have to make the balance between hate speech and individual rights, we can, for example, use the test of the imminent danger. I agree with my friend Peter that this is a very good way to deal with that. But I don't know if we can use this kind of test when we deal with the balance between hate speech and social cohesion, for example. And I will give you an example in order to focus a little bit this discussion. This is a very recent event that has taken place in Spain last week. An imam of a medium city of Spain, made a speech in the prayer, in the Friday's prayer, saying that women should be treated in a certain way, with violence and, well, telling them what to do using violent methods, etc., etc. Well, the kind of stuff you can imagine. Well, obviously this imam has been arrested and prosecuted. And this is obvious because this is a clear case of imminent danger, etc., at least for the certain parts of the Muslim community, etc. But due to that event, we have seen and we have read in the press many articles talking about Muslims and women and the way in which Muslims treat women. Probably these articles are not as dangerous in terms of immediate danger. Yes.
My colleague here has just pointed out that this is already anticipating the second section.
Okay.
So if you'd like to continue it then, and then I'll
okay, no problem.
I'll use the last minute to take
okay.
a quick question from anyone else. Yes.
I just want to say you can take 6 more minutes, Tarlak. I think it would be silly after this very rich session not to take an adequate amount of time to discuss, because we actually want the debate. So I will take responsibility for pushing back the coffee break.
There we go. My popularity ratings are going to be suffering for nothing. Okay.
Thanks very much. Thank you to all the speakers and to the chair for managing like a racehorse commentator so well. I just had a quick comment on Mr. Milo's presentation. I mean, and making all allowance for the constraints of time that you were operating under, I did feel during the presentation, as often during such presentations, that we really need more information if we're to understand what was being claimed, and if we're able, in order to be able to assess the claim that is being made there of incitement, connecting certain kinds of content online with certain actions that took place in that country. So if we are to understand the scale and scope, impact, influence of that sort of material, we need to know who is reached by those messages, in what way they're reached, which media outlets opposed those messages. Presumably some did. Presumably there wasn't a sort of consensus of mainstream media coverage supporting that kind of message about the Roma people, but that's the impression that was somewhat given by the presentation. So I'm concerned that we do not sort of paint with too broad a brush.
I'll invite Dr. Milo to give a little bit more information on that in just a moment, but I saw other hands raised there, and I'll just take those questions or comments quickly in case they go in the same direction as the previous one. So I see Maurice Lipson and Dirk Voorhoff. Yes.
Thanks. I'm struck by the danger test, and in particular struck by the decision to focus only on danger of imminent violence rather than danger of insult and so on. Imminent danger of somebody suffering substantial psychological harm, and I would have thought that needs an argument, particularly in the European context where dignity is a particularly important value. It's not. I come from a U.S. perspective, so I have the inclination to go with violence as well. But in this, here it strikes me as at least needing more argument.
Thank you, Professor Voorhoff.
I'm sure there will be more on this discussion on imminent danger, also in relation to the use of the criminal prosecution of hate crime on the one hand, but also the positive obligations. I think that needs to be further developed, because if you ask imminent danger before starting to prosecute, what is the positive obligation of the state in this area? But I have one specific question coming back to media and journalism, referring to the introduction by Aidan White, and also a very brief sentence in between by Barbara Bukowska. My question is, how can media and journalists be better integrated in a policy of tolerance and respect for minority rights, when it is the politicians themselves who in their statements, in their interviews, in their interventions and in their programs themselves incite to hatred and intolerance towards groups. I've been involved in a project in Bosnia-Herzegovina where we saw these tendencies very sharply in Sarajevo, Banja Luka and Mostar, but also in the Flemish community we have politicians who have this very strong language, also statements in parliament which are protected under parliamentary immunity. And of course that's part of political debate, it's reflected in the media. My question is, how can media at the same time play their role and bring that important aspect of what politicians have to say and at the same time not contribute to further incitement to intolerance in these societies?
Thank you very much. That has occasioned some rapid note-taking there. I'm going to take one final comment or question from Mr. LaRue, and then I'll try to get responses to a few of the questions and comments already made.
Thank you. I'll be brief. I just wanted to establish some questions for reflection. Number one, precisely on the question of imminent danger, is danger of what? Can it only be danger of violence or not? And effectively, Article 19 in their benchmarks to the contribution, one issue was imminent and clear danger, and another issue was the real possibility of danger. And they make a difference of the two of it. And the third was the context. In what context is this danger real or not? For instance, the call of the Milcolin radio in Rwanda was relevant to the tensions between the Hutus and the Tutsis at that moment, and that historical moment. So it actually was part of the incitement to genocide. Secondly, the second question, and I have difficulty in this, always, because although I do believe that there should be restrictions to freedom of expression, my main role is to defend the right. So obviously I find it complicated to put the limitations. And I'm not sure when international human rights standards talk about prohibition, if we should always understand that as criminal law or not. I personally don't believe so. I think prohibition could work in many ways. Now, well, number one, it was already said several times, the proactive responsibility of the state to prevent these issues and the whole role of prevention. Secondly, prohibition could be criminal law, but could also be civil sanctions and forms of reparation, or could be the dismissal of public officials if they so use these statements. There can be more than just criminal law. And the reason why I say it is not because they're not grave faults. I think expressions of hatred should always be seen as something horrible and serious. But the reason is because if you create the criminal legislation on this, there's always the temptation of politicians to misuse it, to misuse criminal law on hate speech as they're misusing criminal law on anti-terrorism, although anti-terrorism may be legitimate. But once you create the law, the political temptation of misusing it will be there. So I think it's a matter of reflection. And finally, one expression of that you were mentioning, I think the Holocaust denial laws in Europe, and I mainly made a comment on the denial of the Armenian Holocaust. There was the legislation in France. I believe they're horrible statements of prejudice and racism, but you cannot write history by law. I think that all the same way I mentioned to the Islamic conference that there is no defamation of religion, I don't think you can define history by law. And I think history will always be open to debate, hopefully in the most respectful terms. But again, I mean, this for me is stretching the concept of what prohibitions can be.
Thank you very much. For what my very humble opinion is worth, I think it's very, very good that you've homed in on what the possible meanings of prohibition could be. I would agree with your analysis of the term, and I think it's something that came up in the context of the drafting process of General Comment 34 by the Human Rights Committee, and that was a very, very crucial discussion point for them, that it was distinct from punishment as such, and that prohibition could be achieved by other measures. Okay, we've had a number of questions now going in different directions. I'm going to very quickly see if the people who were most implicated by those questions and comments would care to give a quick response. So I guess the first one would be Dr. Milo. Would you like to provide just brief context or address this underlying concern for a need for more context? If you would like to respond to that maybe in a general way.
Yeah, of course, due to time constraints, I wasn't able to illustrate all the other cases, but maybe just to clarify it briefly, what I did try to show in the presentation was not the link between the shooting and the hate speech, which is omnipresent in the Slovak internet and also in the media, but on the other hand to show that even in such horrible cases, you know, a mass murder of 6 people, if the victims are Roma, this crime was perceived or at least portrayed as an act of defense by the perpetrator. There were even some groups on Facebook, again, which demanded or suggested that the perpetrator of this crime should be proclaimed a national hero for what he did. And this case comes up again and again in other similar cases where there are some tensions between the majority and Roma population, and using this case, you know, as maybe we should do the same thing what Mr. Harman, who was the shooter, did in Dievinska Nova Ves. So I'm just trying to say that all such cases and the discourse create a context where even a hate crime, not hate speech, a hate crime, an act of violence against a certain group in the society is perceived as legitimate. That was basically my point.
Thank you. And then, first,
just very briefly on the issue of personal harm that was raised at the other side of the table as an issue. I, of course, didn't have the time to get into the victims, but we often too easily assume, well, at least lawyers too easily assume, that if there's harm being done by hate speech, that introducing hate speech will alleviate this harm. And another aspect of my research actually shows that this is not the case, that in many cases actually the introduction of the hate speech legislation adds to the harm concerning victims. But I won't take too much time. We can get into this later on the day if you'd like.
Yes, thanks very much. I mean, just very briefly on the this point that Dirk raises. I mean, it's absolutely right, and I think the studies that have been done by the Mediva Project actually illustrate that the way that journalists work is actually not necessarily from some inherent prejudice that exists within the newsroom or the news gathering process, but is very often manipulated and driven by political forces, and I think that's very, very clear. You've only got to see the influence of politicians like Wilders, for example, and their capacity to take advantage of a willing media. So media-savvy, unscrupulous politicians are very much part of the problem. The question is, media, of course, have to report these and so on. And it seems to me that part of the Open Journalism Project should be a recognition that the role of journalism these days is much less to report particular events, much less to give intelligence about what has happened and what is taking place, and is much more to provide context, analysis and commentary about what is being said and how it's to be understood. And therefore the response really is that, that in dealing with this, journalists and journalism has a responsibility to put what politicians say and how they behave in context. And so therefore that's also part of that sort of challenge of, you know, ethical conduct, that it is is a question, is it ethical for journalists to reproduce information and statements without context, without analysis, without commentary? And that raises a very, very significant and important question about how does journalism function if it's got a responsibility to take statements and put them in a proper context. And I think that's why we need to take this ethical debate out of the the sort of theoretical area and put it into the newsroom and the discussion. And I think therefore work that's been done like organizations like the Media Diversity Institute, who I work with, and others who are sort of promoting this raising of awareness inside journalism is absolutely vital to creating this new culture. But I mean, I think in these uncertain times in which we're living, this is a primary danger that's been highlighted.
Thank you very much for that contribution. It's also strategically brilliant because it takes us to the heart of session 2. So let me then, trying to apply the timekeeping to myself, thank all of the panelists very much for their contributions. Thanks also for input to the floor. Again, because of the constraints of time, I'd like you to try and compensate for that by making a beeline towards the speakers to pursue any points they've raised with them in a more informal setting. So again, thanks very much for the contributions and also for bearing with me as I try to be Michael Jonian in my moderation of this session. Okay, round of applause for the panelists. Thank you.